All right, good morning, everyone, and good afternoon. We have a number of participants on the West Coast. That's the reason for my good morning. And we have a number of people both on the East Coast and in the Midwest, and good afternoon to all of you. I'd like to welcome you today to our webinar on return to work policies and the legal implications of those return to work policies, and also planning for an effective return to work strategy. What we're going to be covering today is a comprehensive return to work plan to try to keep your employees safe. We're going to describe the best practices and training considerations for new protocols, workplace modifications and procedures to get your best resources back to work safely, guidelines on how to recall existing and hire new employees as your business recovers, and then understanding the 10 legal principles, actually there's 11, and I'll explain that later, implicated in return to work strategies. Presenting today will be myself and Melissa Schaefer. Melissa and I are the co-chairs of the Hinshaw and Culbertson Labor and Employment Practice. Both of us have been representing management, labor and employment clients for decades. We both dedicate our entire professional life in dealing with labor and employment issues for our management clients. Now, a friendly reminder, if you have any questions during the program, use the Q&A button on your screen to enter those questions. We're going to do our best to address as many questions as possible at the end of the program. We believe, based on a lot of the questions we've already received, that a lot of them will be addressed as we go through our slides. Additionally, the final slide has our contact information, so please feel free to reach out after the webinar. And so thanks to all of you for joining us, and let's get started. Next, please. Now, many states are entering the reopening phase. We're doing so in Illinois. Our clients are also doing so in California. Clients in Indiana have already been opened for many of their businesses for over a week already. Just as states, counties, and municipalities are doing so in a phased process, so too are many of employers. We're going to deal with the interplay between the practical issues implicated in various return to work scenarios, but we're also going to match those up with legal and liability issues. The majority of these legal issues address employment concerns, but as the slide indicates, there are also third-party liability and privacy concerns which must be addressed. So put simply, we want you to walk away from this presentation with a list of both practical and legal concerns that you must address as you are considering your return to work strategies. Next, please. These are the simple goals. And they're reflected here. They're straightforward. We're going to provide a list of practical steps and issues which should be considered as you switch from remote working arrangements to an office or place of business, or from a shutdown to a reopening of your business. Many of our clients have basically been shut down completely during the last 2 months. So the immediate goal is a better understanding of the necessary tasks which should be considered. The second goal is development of that practical legal checklist. A lot of you are familiar with the way Hinshaw handles our seminars, our blogs, webinars like this in the past. And we have always tried to mix the legal with the practical so that you can have some valuable takeaways at the end of the webinar itself. Next, please. So the first takeaway is a basic understanding of the legal issues. And it allows you to plan with an eye toward mitigating risk as you go through this. As indicated earlier, there are 10 legal issues that must be considered in any return to work scenario. I also mentioned that 11th one, and that 11th one is really retaliation. And as you'll see in some later slides, retaliation is implicated and protected in any number of the various statutes that we'll be discussing. So over the course of the next 2 slides, you're going to have a useful checklist to assist you in working with your in-house counsel or your outside counsel, if you are in-house, to develop and implement your own checklist to compare against your return to work policies and procedures. Now, I know the audience includes attorneys, and this list only includes what I call the top 10 or 11 of the legal issues. There are more, but these are the most important. Next, please. So let's start with the 10 principal legal issues. The first is common sense. You have to understand and comply with any guidance and executive orders from any federal, state, or local authority. Second, you must understand what type of workers' compensation issues will arise as a result of exposure in the workplace. My partner, Melissa Schaefer, is going to be talking more about that later on. Third, we're going to talk about OSHA requirements and preemption. Specifically, we're going to talk about the general duty clause and its applicability to almost all of the employers on this call, as well as PPE requirements that we would recommend and in many cases will be required by OSHA. We're going to talk about premises liability concerns to third parties. That's not strictly a labor and employment issue, but it is an important issue to consider as you decide how to implement your return to work. We're going to address employee privacy concerns, HIPAA, and state law privacy claims. Now, just so you know, those state law privacy claims generally are implicated in the form of the public disclosure of private facts. And this could be exposure not only to your own employees under state tort laws, but also to invitees, such as visitors to your premises. The goal, obviously, is to limit exposure in this regard. There's a lot of misunderstanding about HIPAA. Most of you, and I've looked at the list of the individuals who have signed up, are not covered by HIPAA. You're not a covered entity, in other words, but you do have employee privacy concerns and third-party privacy concerns that you have to address. Next, please. Just as I indicated, invitee privacy issues and state law concerns will arise as we discuss a number of planning and tracking devices that might be put in place as a result of your return to work strategy. You may ask individuals who are visiting your office to complete a health questionnaire, for example. We'll be talking a little bit more about that later. Obviously, we're going to be dealing with employee leave and compensation issues. Specifically, we'll be dealing with those under the FFCRA. We have to consider unionized environments and collective bargaining obligations. This is one you certainly can't ignore. The risk is taking unilateral action and having that violate either a specific term of your collective bargaining agreement or perhaps your duty to bargain in good faith with the union. In addition to that, there are also Section 7 considerations which must be addressed. And every employee in the country who's not a supervisor has a Section 7 right under the National Labor Relations Act. And we'll talk about what that means a little later as well. Whenever we're dealing with return to work strategies, we also have to consider not only the FFCRA, but historically the FMLA and related Americans with Disability Act concerns. We have to discuss employee compliance and disciplinary issues under federal and state law. And on top of this, we cannot forget about the retaliation issues. This is the 11th one I talked about before. The ADA and the FFCRA, for example, have fairly strict anti-retaliation provisions. Those of you who do business in Chicago will recognize that just last week, an ordinance was passed with specific anti-retaliation provisions. We don't have time to go into all of these 10 legal issues, but this should be a useful checklist for you to use in the course of planning for your return to work. And with that, I'm going to turn it over to my partner, Melissa Schaefer.
Thanks, Tom. I hope everyone is doing well out there in Zoom land. When evaluating the return to work decision, obviously we need to adhere to government and health authorities in reference to what they're saying that we are allowed to do. So each business, each facility, each corporation needs to make the decision on whether they are allowed to move forward with opening, and if so, how they will do it. Obviously, we all need to be concerned about a too early return, as that could lead to additional complications and cost later on. The general considerations that employers need to make before evaluating whether to return to work include obviously state and local authority on whether they can, to make sure that they are in compliance. After that decision has been made, or you know what date that you are anticipated to be able to return to work, then there are some other considerations that you need to do. One would be, if you've been fully shut down, do you need to go in and do a full clean and disinfect before you do so? If you've had some people in the place of business and then you're sending the rest of the people back on a staggered basis, which will be discussed later, do you also need to do a clean and disinfect? You also need to be prepared with PPE. As Tom had mentioned earlier, with personal protective equipment, the employer needs to be ready to provide what is necessary to their employees to maintain safety, in addition to maintaining adherence and risk management factors. Now, an employer needs to evaluate physical barriers and the physical design of their space. Does it need to be redesigned? Do additional things need to be added? Do things need to be removed? All questions that they need to answer in order to make the decision, are you ready for people to return to work? You also need to discuss and have an understanding on your reintegration of technology into the workplace. How is that going to work for you? Tom will be talking about that a little bit later on. In addition, Tom mentioned employee willingness and anxiety in returning to work. Some people might be fearful of returning to work. What do we do in situations like that? How does an employer react to that, and what are the best steps to take? We'll be talking about that later. We also need to talk about lessor requirements. What is your landlord, if you have one, doing? What are their requirements, and how do you need to change your policies in order to comply with that? The other last topic of general consideration is multi-facilities and multi-offices. As Tom mentioned, different states have different requirements going on right now. There are states that have phases. There are some states that are in certain phases and some states that are not. Some states are open, some states are not. The same goes for cities. So you need to make the decision with reference to each of your locations because they may be different. There's basically no magic formula, and you're going to need to sit down and evaluate each one individually and uniquely. Next slide, please. Everyone is going to be facing pressures to reopen. We've all been watching the news, reading the news, and there are competing pressures all the time that we are hearing about regarding the acceleration or delay of the reopening process. It has basically been determinative based on your type of business, your location of business, but also monetary reasons. We have seen some businesses who are pushing to reopen simply because they cannot stand to be closed anymore for financial reasons. In addition, there's productivity concerns. Obviously, the less amount of people working makes your productivity go down. Obviously, people are trying to increase their monetary and financial status, as well as trying to get people back to work and watching the unemployment numbers. With regards to that, client demands and production schedules might dictate timing on the implementation of the return to work strategy. Production facilities need to evaluate what they can do, what they cannot do. What is their supply and demand? All of those things will go into evaluating whether you are ready to reopen, and again, how to do so. Next slide, please. Now, there's always going to be a cost in reference to bringing people back to work, unfortunately. Because of the pandemic that we've experienced, things just aren't the same. I mentioned earlier cleaning. Now, cleaning costs can be extremely great depending on your space size, and that is something for you to really consider in determining whether you're ready to bring your employees back. We have done an evaluation on a smaller space, and the quotes that we have obtained could range in between $10,000 and $20,000 to clean a small space. So if you can imagine, if that's a small space, a large warehouse or production facility might actually incur cleaning costs in the amount of 6 figures if that needs to happen because of an infection or something like that after the workforce is brought back. The other thing you need to remember is that the cleaning, just because you clean it and disinfect before everyone comes back, it's now a regular thing that you must do. You're going to need to have a policy in reference to what you're cleaning, how you're cleaning, and how frequently. And it definitely is recommended that you have written this policy down so you are protecting yourself on a risk management standpoint in reference to what actions you are doing to ensure employee safety. Now, the redesign of the place of business. Many of us know that Silicon Valley and the tech firms have all been a fan of the open space concept. That concept is not looking so good right now, and I think those people who have open concept need to evaluate how they're going to make that space work for them. That could include redesigning the space in reference to adding cubicles, putting up physical barriers. The plexiglass business, as we all know, is going through the roof right now. That needs to be evaluated in reference to how good and how safe your space is. The additional thing to remember with regards to reopening, and we'll go into more of these issues as we move forward, is the possible workforce exposure to COVID-19. Again, if you go back too early or you do not have the right measures in place, you could have an infection or a spread, and that's going to just incur additional costs for you. So you need to evaluate that in addition to your supply of PPE, in addition to the cost of PPE. If you have enough PPE to provide your employees for a week, that's not going to be enough to sustain you to remain open. This is something that needs to be considered before you open those doors. We're recommending anywhere between a 30 and 60-day supply of PPE before you reopen your doors, because we all know the supply chain has been very difficult with regards to PPE. You'll need to make sure you secure that and keep that going. And again, if you make the decision to reopen too early, that could end up costing you down the road, because again, those cleaning costs can be quite extreme. And the other thing to remember is sometimes when you reopen something too early, or the people that you have just coming back, you might have contamination by third parties. And so you have to remember, if your office or your business is open, third parties are now coming into play and could be bringing in exposure to your facility or premises. Next slide, please. We've all heard tons on social distancing. The CDC obviously has their recommendations, but it also is something that's going to assist with employee anxiety. So it is up to you to decide what would work best for your facility in reference to social distancing. And I'm not saying that we go beyond or below 6 feet. That's obviously the CDC standard. But what you want to do is make sure that you are implementing it into your facility in the best manner possible. And again, that could be with one-way traffic down certain hallways or things of that nature, because there are going to be places in your facility where social distancing is quite difficult, if not impossible. And that's where you're going to need to have some policies in place in order to protect your employees. Next slide. So going through the steps, step one is obviously preparing to implement your return to work. So once you know what date or what your plan is for the return to work, now it's time to dig down and get everything going. And the first thing you need to do is create a committee or a group of people in your management to coordinate how you are going to do this. You need to consider who the necessary participants are for your specific business. Most of the time you'll have IT personnel, because technology goes hand in hand with the reopening. You'll have human resource personnel to protect on the legal issues and the return to work issues, as Tom had previously mentioned. And you're probably going to need some office managers, office services, as they are the ones who deal with the employees on a daily basis. Mainly it's going to be leadership. Some businesses might choose to also include outside counsel on that. And that way they have legal involved as well. But the main thing is to evaluate your business, pick the people that will be best for you, and arrange that committee. Next slide, please. Once you have your committee in place and you are setting your meeting schedules, you need to look at step 2, which is the state and local requirements. Tom and I both mentioned previously that the requirements are different depending on where you are located. It also is different depending on whether you are an essential business or an operation that's been subject to closure or isolation requirements. So you need to consider the state and local executive orders concerning these requirements and evaluate the potential consequences of not complying. For instance, you could risk losing your business license if you do not comply with state and local executive orders. You may secure fines from state and local authorities. You might have a downstream of tort liability because of exposure to third parties. And also you have to think about your employees. This could expose you to additional employee lawsuits because your place of employment is not safe. So you need to consider the local remedies in your jurisdiction for the non-compliance as you evaluate your return to work. And with that, I will turn step 3 over to Tom.
Sure, and I have 2 comments on some things that Melissa has said. One is on pressures to reopen. You're going to find that any employer is going to have multiple voices advocating for either waiting or for opening early. And really the big lesson is to do it at your own pace. So for example, if you're in a business where remote working is actually acceptable and productivity has remained high, consider yourself lucky. You can wait. You can do so in a measured fashion. Contrast that with a third party, or excuse me, an employer who really can't function on a remote basis. Well, then that's not an option, and return to work must be accomplished as soon as possible. It's a cost-benefit analysis. As Melissa has indicated, there are some very, very significant costs incurred if you open too early, and there is reinfection in the workplace, and you have to go remote again or even shut down again. That's what you really want to avoid. The same thing applies with employee anxiety, and don't minimize that. We're seeing it in our own firm. We have 900 people in our firm with over 400 attorneys, and we're seeing a whole variety of different approaches and sensibilities toward how this pandemic should be handled. So to the extent you can accommodate remote working, again, consider yourself lucky. With regard to that committee that Melissa suggested, you're going to find that what she identified were really the principal components and specialties which must be included. And we would urge you to make sure all of those specialties are included. But that committee is going to evolve over time as you determine what's most important in your facility. Now, let's talk about step 3, which is facility readiness. PPE is a no-brainer. It must be assessed and it must be available. PPE includes such items as gloves, masks, and hand sanitizers. And depending upon the work of your business and the proximity in which your employees work with each other, you may need additional PPE, such as plexiglass shielding or face shields. The supply chain for replenishing PPE must also be established. Supply chain is critical. You're going to see in a later slide that you need to have backup, and you need to have alternative suppliers put in place. A plan must be prepared for pre-cleaning and post-incident heavy cleaning if necessary. You need to know the cost, and you need to know the cleaners and their availability. And keep in mind, your lessor may limit the cleaners that could be utilized by you. Your lessor may dictate the cleaners that will be used. Next slide, please. So you have to coordinate access issues, not only for your employees with your lessor or perhaps even with co-tenants, but you'll see you'll have to coordinate that for your cleaners. Different buildings may have different requirements, and it's extremely important that you understand what those issues will be. You do not want to be addressing these on an ad hoc basis as things go forward. You're going to want to be proactive with your landlord to make sure that you understand each and every one of your landlord's requirements. You have to plan and prepare for transportation delays. If you're in a high-rise building, there's likely to be limitations on elevator use. There will be public transportation issues. As a side note, I will tell you right now that I have the luxury of walking to work, but I happen to see buses go by me every day. I happen to see the L go by above me, and there are very few riders on it. There is going to be natural employee anxiety over the use of public transportation. So there has to be some risk assessment of alternatives. Some employers are thinking about subsidized carpool. Now, in a carpool, the risk of exposure to the individuals in the carpool is also there, but it's probably less than public transportation. Again, these are issues to think about. Melissa will talk a little later about phased or structured entry into the workplace. Next slide, please. This is step 4, and we're going to get into a little bit more detail here with respect to PPE and inventory. You need to identify your current inventory stock, and I will bet, not my mortgage, but probably Melissa's mortgage, that currently you don't have enough. At a minimum, you're going to need masks, gloves, wipes, hand sanitizer. The masks and the gloves, you're going to have a multiplier for each employee because many of them can only be used once or can only be used for a short period of time. Depending on the nature of your work, you also may need gowns or face shields. Face shields, especially if you're working in close proximity in a production facility, for example, or gowns in a healthcare facility. You're going to have to identify those likely suppliers and establish a preferred relationship. Now, what does a preferred relationship mean? It means that you might have a guaranteed stock, or you may have a guarantee of delivery of supplies within a short period of time. This may require additional cost on your end, but if you're going to reopen, it is better to have the necessary PPE than not have it. Keep in mind that not having PPE could lead to employee claims, and we'll talk a little bit about that later. But let's go to some of those employee claims. You have to understand the OSHA requirements. The general duty clause applies to basically every employer that's covered by OSHA. And that's probably everybody on this call with the exception of public employers who may be covered by corresponding state laws. There are also industry-specific requirements. Just so you know, there is a wonderful OSHA enforcement memo that's online and available about the approaches that agency is going to take with regard to PPE, recording illness, handling employee complaints, and general employer responsibilities. It's one of the first things you will pull up if you Google OSHA COVID enforcement memo. It'll come right up for you. Also keep in mind with respect to OSHA that COVID is a recordable illness. Back in March, when it was first declared as a pandemic here in the United States, it really wasn't sure whether it was a recordable illness or not, because generally illnesses such as the flu were not considered to be a recordable illness. But OSHA, within 3 weeks ago, has said that it is a recordable illness. And it's recordable if it's A, a confirmed case, B, it's work-related, and C, one or more of the recording criteria exist. Now, I'm going to focus a little bit on work-related because that's the real issue. Did someone become exposed to the illness or the virus because they took public transportation, or were they exposed in the workplace? One of the things that OSHA has indicated that they will look to in this regard is the number of cases for employees working together in close proximity. If that fact is present in your workplace, more likely than not, that is going to be an indicator that if a positive result occurs, it'll be a recordable illness. And it has to be based on information which is reasonably available to the employer. Next slide, please. Step 5. Employer readiness is key to retaliation claims. It's almost going to sound mantra-like as I talk about this, but I think the key to providing or preventing retaliation claims from your employees, or perhaps even whistleblowing claims, is to have a return to work plan, and then to educate both your management and your employees about that plan. That begins with understanding employee sensitivity and anxiety. A lot of employers are thinking about the use of employee surveys. How comfortable were they, for example, working remotely? How comfortable will they be returning to the office and working in a traditional work environment? How comfortable will they be with respect to their transportation issues? These employee surveys do a couple things. One, they communicate to the employee that the employer is not really doing this unilaterally, but they want to take into consideration employee concerns and to see if there are any workarounds that can be accomplished. It also lets you know where there may be some problems that you'll have to plan for. You want to educate your employees on return to work, and principally the idea here is avoid misunderstandings. You want to let employees know that if they have concerns, they should bring their complaints to a designated individual in the workplace. You want them bringing complaints internally and not going externally with their complaints, like to OSHA. It should be a written plan that the employees can refer to periodically. Management training is also important. Now, the managers aren't going to understand each and every nuance of various federal and state and local statutes, or even the isolation orders or the executive orders that are in place. But one thing they do understand is that they shouldn't, or should be able to understand, I should say, is that they shouldn't retaliate against an individual because they are questioning whether a particular process is safe, or if they question whether PPE is available and there's enough of it, or if they have to care for a sick child or a sick immediate family member, whether they can take time off. You cannot retaliate against an individual for doing so. There are a couple of statutes that are implicated here. The first, obviously, is OSHA. And OSHA itself has an anti-retaliation provision in Section 11C of the Act. And it preempts, well, I shouldn't say that. I'm getting ahead of myself a little bit. It protects employees, I should say, against retaliation by an employer because they have a legitimate safety concern. I'm going to talk about preemption a little bit later as sort of a defensive mechanism that employers can take. Also keep in mind the National Labor Relations Act protections for employees when they raise these concerns. A lot of employers say, why am I concerned about the National Labor Relations Act? I'm not unionized. As I indicated earlier in the session, every single employee covered by the doing business and commerce provisions of the National Labor Relations Act, and that's almost everybody, has Section 7 rights. And Section 7 rights include the right to raise safety concerns as part of concerted protected activity. And if someone retaliates against an employee, there's the possibility that an unfair labor practice charge under the National Labor Relations Act could be brought, and the remedies available under that law would be available to the employee. There is also common law retaliation, and then there are state whistleblower issues that have to be considered. Next slide, please. I mentioned OSHA preemption as a defense. And although we haven't seen a lot of retaliation cases being brought so far, there have been a few. What we have seen is is a lot of commentary from so-called experts. There is one decision that sort of made it down the road a little bit. And we've seen that OSHA preemption can be a very effective defense. You may have heard about the notorious Smithfield issue regarding a food processing plant. And state law whistleblowing and state law claims were made. And the lawyers for Smithfield were very effective in using OSHA to preempt the state law claims that were brought. So one of the things you're going to keep in mind, hopefully you'll never get a claim, but if you do get a claim, talk to your lawyer immediately. Make sure you mention the possibility of OSHA preemption in your case, and make sure your lawyer knows that it should be removed to federal court if possible. One of the good things about OSHA retaliation is it's investigated by a very competent and very good group of investigators at the Occupational Safety and Health Administration. And there's an administrative process that has to be followed. So not only can you perhaps kick it out of state court with preemption, you can probably get the federal court to stay proceedings until OSHA investigates. And OSHA generally has a bad rep, I should say. I'm not sure why. I have found it to be one of the agencies that is very well run and very effective, and quite frankly, very fair to employers. You also want to make sure that when you're considering employee concerns in this regard, that you give notice to a union if there is one, and be mindful of your bargaining obligations. Analyze the requirements of a management rights clause. So a lot of things we're recommending include the development of various policies, as you will see, a pandemic policy or a self-monitoring policy for employees. There will always be a question in a unionized environment as to whether or not you have the unilateral right to do this. The management rights clause is probably going to be the provision in your collective bargaining agreement you're going to have to look at. And even if you have the right to do it, you'll have to understand the impact and effects of effects bargaining. In other words, you may have the right to make or implement the decision, but you may have to negotiate about the effects of that decision. Next slide, please. Melissa mentioned before I was going to talk a little bit about technology readiness. And a lot of this means that you have to, that employees have equipment at home that they've been using. You need a process by which to accept, receive, and disinfect returned equipment. We know that the virus can remain active on hard surfaces for many days, sometimes up to 10, depending on who you're listening to. You have to respect and adhere to inventory controls for purposes of a contact log in case there is an unfortunate exposure in the workplace. And you want to keep a record of sanitation steps as a defensive measure in the event a claim is ever brought against you by an employee or even an invitee. With technology, you're able to maintain an agile workforce, which means that a lot of employers have been able to have a remote workforce. So take advantage of that. Anticipate and implement, if you can, a phased approach to returning the workforce. Perhaps implement plans for shared equipment if you don't have enough. Plan for a possible return to work from home status if necessary. Next slide, please. This is an important one. You need to prepare and think about what happens if there is a reinfection scenario. Are you going to be shut down completely? Are you going to be shut down again partially? You need to think about what you're going to say to your employees, how you communicate this to your employees. Do you have a means by which you can tell your employees either by email or by text message or by phone that they should not be returning to work? It may be that someone after hours is going to tell you that they has fallen sick and have tested positive, and you're going to need to notify the employees in the work area perhaps not to come to work. And you need to create your own checklist of steps to follow if an infection or reinfection occurs. In other words, prepare. and you should continue to assess your long-term changes in staffing and work site. With that, I'm going to turn it back to Melissa to take us home with the rest of the steps.
Moving on to step 7. Once you have put all your ducks in a row, now it's time to prepare in order to implement all the processes and policies that you've put together. Tom's touched on a little bit of some of these with regards to transportation. How are you going to address that with your employees? One of the biggest suggestions we've been hearing and giving out is flexible start times. It's common knowledge that for the most part, the 8 and 9 a.m. time frame is usually the busiest. And then right around the 4 to 5 p.m. time is the busiest at the end of the day. So with respect to those two time frames, perhaps a staggered shift start time would be helpful for your employees using public transportation. Tom mentioned that the buses and L are not very busy right now. But as we all know, once the economies become up and running, they are going to be increasing in the areas where public transportation is a mode of transportation. In Los Angeles, as many of us know, California people, Los Angeles, we tend to drive. Public transportation is not as utilized as it is in places like Chicago or New York. So that has actually been touted in some of the articles, in that one of the reasons why Los Angeles has not been as bad as New York is because of the public transportation system, because so many people drive and don't use public transportation. Another thing to consider, which I know Hinshaw has done for some of their people as well, is in reference to subsidized parking. If there are people that are essential and they are coming in, but they can only use public transportation, perhaps it's something that you need to look at into giving them a parking spot somewhere if they can, in order for them to stay safe and come to the place of employment. You also need to evaluate addressing caregiver concerns. As we all know from the laws that have been passed with COVID, there's additional time off and sick leave that can be taken when there's caregiver issues. So you need to evaluate whether there's somebody taking care of somebody who has a serious health condition and how that's going to affect that person in the employment situation. Do they need additional time off? Do they need different schedules? What kind of accommodations might be needed? And each of these need to be addressed on a case-by-case basis. You want to do your best to understand the issue and communicate with the employee. Communication is going to be the key thing that will make things better, because as long as an employee sees you as understanding and communicative and willing to listen, you're probably going to be better off at the end of the day with reference to future claims and things of that nature. Next slide, please. As Tom mentioned, a phased return is probably and likely what you're going to start with. It would be most likely unsafe to return everyone all at the same time. So in considering a phased return, you need to evaluate who are your essential people, what part of your business is going to be up and running, and where do you need the people first. And then you should do your plan accordingly. It could be involving partial staff returns, staggered hours or schedules. You could also have like a team A or A team and a B team. Maybe there's certain employees that work Monday, Wednesday, Friday, and certain people that work Tuesday, Thursday, and then you switch every week. The important thing, again, is communication and figuring out how it will work best for you. As Tom mentioned, if you're lucky enough to be able to work remotely and your employees are doing well, you really are lucky in the context of keeping that social distancing in place and keeping the safety of your employees. But there is going to be a challenge, I think, for many employers where somebody was working from home, and while they were able to do the majority of the essential functions, that they haven't been able to do 100% of the essential functions of the job. So now that you are able to reopen and you can get people back to the place of business, how is that going to work? And some people may be asking for accommodations under the ADA, depending on their individual situation, in reference to, I'd like to continue to work from home. And we've all seen the cases over the years. Working from home has not always been given as an accommodation. And employers have argued in the past that that wouldn't work for them. It's going to be likely harder to make that same argument right now. So you need to evaluate each case individually in order to determine if the remote work will continue to work once you do reopen. And again, cleaning. We've mentioned it numerous times already. You need to create the policy that all employees follow as well in order to create a safe place of employment. And with that, as Tom mentioned, it needs to be followed consistently, and you do have to have some plan in place for the employees who aren't following procedure. Next slide. In addition, again, we talked about the social distancing, 6-foot separation. We've already talked about the alternative weekly schedules. You might need to separate workstations or only make certain workstations available. If you have a cubicle situation where they're close together and it's, say, a pot of 4, maybe you can only have 2 people in that area at that time. Again, individual decisions need to be made. Now, you might also have to consider prohibiting meetings that are in smaller places. You might have a small conference room where social distancing really isn't that feasible. You might just need to close that room for the duration of the pandemic. We're encouraging in-house use of technology. Obviously, we're presenting this webinar via Zoom to make sure that we all are safe. Next slide. Common space is going to be a big issue. Again, not just in conference rooms and things like that, but you also have to evaluate kitchens, restrooms, conference rooms, break rooms, things like that that are utilized by everyone that is working. There is a discussion that joint refrigerators or shared refrigerators in a kitchen or a break room should not be utilized because people will be putting in their own individual food items that have come from home, and then you're putting them in with a mix of others. There's also talk about not having any shared coffee. As we know, with a lot of offices, there's the coffee pots and people just grab a pot and pour themselves a cup of coffee. That's probably not in your best interest right now. You need to evaluate what will work for you or what's safe. It might be where you are simply providing disposable cups and that's all you provide, and they have to bring their own beverage. Again, something for you to consider. Tom mentioned the plexiglass barriers. So we won't talk about that again. But the other thing, think about entryways, walkways, and doors. Think of all the touching that goes on with all of those things. With regards to doors, you might have to have somebody come in every morning and maybe open all the doors, and the doors stay open throughout the day, and then they're closed at the end of the day. Does that work for you? Again, individual decision. Is there a way to do touchless entry to the doors? Do you need to install different things in order to make the doors open automatically? Walkways, how wide are your walkways? Do you need to do one way? Do you need to mandate mask wearing in the office because there's no way to maintain social distancing in those walkways? And the same for the entryway. Next slide, please. We've mentioned this before with regards to individual people having conditions or taking care of people with conditions. Again, the most important thing is to evaluate on an individual basis and assess ADA issues, do the interactive process, and make sure that you are documenting all decisions that are being made in order to protect yourself for future risk management. And in regards to accommodations that might be requested, you need to remember that the employee does have to ask. And it can be in verbal, it can be in writing. But another thing to remember, which we'll touch on in a little bit, if you do have somebody who you do know is immunocompromised or has some underlying medical condition, simply because you know that does not mean that you treat them any differently. They still have to ask for something, ask for the accommodation. So if you have that employee and you're thinking about bringing people back to work and you know that this person has a medical condition, it's not your decision to not include that person. That person has to bring it to your attention for you to evaluate. So please make sure you consider that too. Another thing to remember with regards to the self-monitoring policies, you may put some procedures on your own employees. You tell them these are the symptoms that we're looking for. If you have any of these, it's up to you to tell us. And one of them, it will be your temperature. As we know, a high temperature or fever is one of the symptoms of COVID-19. So in that regards, do you want to set a number? What is the temperature that you're going to look at? I've seen multiple employers using 100 degrees as their threshold. You need to decide on that and then let the employees know so they know what to follow. Obviously, we've also heard about sore throat. We've heard of loss of taste, loss of smell. So in those references, if they have those symptoms, the cough, have your employees let you know. Next slide. When you're beginning to return to work, again, the testing requirements. We've had some questions on this one. Temperature was just touched upon, and the question might be, is that allowed? And it is. But what you have to consider is how you do it and the steps involved. With the temperature check, you need to make sure that you are paying your employees if that is compensable time. You cannot have somebody, depending on your jurisdiction, who before they enter the workplace and clock in are standing in line waiting for their temperature to be checked before and not get paid. For instance, in California, that would be a wage and hour violation. The other thing to remember is if somebody does, let's say 100 degrees is your threshold temperature and someone has something higher than 100 degrees, then you send that person home. Do you have to pay them for that time? What is your policy? Do you have a contract? You need to evaluate all those issues to make sure that you are adhering to state laws in order to avoid future litigation and risk management. The other issue that's been discussed is when you do temperature checks, obviously you should have a non-contact thermometer. I think that goes without saying, but then are you keeping any records? There is a discourse between webinars that I've attended on this issue. Some people say don't keep any records at all, and some say keep records, but be very vague about it. For instance, if John Doe is being tested and you're putting down the information, maybe it's just a yes or a no versus a number. And then you have to remember that that is still private information, so you cannot put that with their personnel file. So you want to make sure you're storing the records in a correct place if you're storing them at all. Again, things to evaluate with your counsel. Now, there's been talk about when somebody has tested positive or has been exposed, what do you do? A negative test, sometimes people are requiring one negative test after a positive or two. You need to think about that and put that in your policy. It also should be determined on how many, excuse me, what kind of testing you're going to require before returning to the place of business. The EEOC has come out on April 23rd, noting that an employer may require testing for COVID-19 and screening, and that a mandatory test must be job-related and consistent with business necessity. This would also apply if you were hiring a new employee. So if you're hiring a new employee, you can require a COVID-19 screening. With regards to the notification of employees with regarding positive tests or an infection in the workplace, you should also have a plan of action in place for that as well. Consider the privacy concerns. What we are recommending is if you do find someone who has been exposed or who has been infected and has tested positive, it might behoove you to ask that person if it would be okay if you tell people who they are. And I know that might sound weird, but if you have their permission to say so, it'll make your life a little bit easier with contacting the people that they've come in contact with. Now, if that person says, no, I would like my privacy, you obviously have to adhere to that. And in that case, it could make for a little bit more increased anxiety because the workers will be talking about who is it? But as we all know, people talk and people might figure it out and then you haven't said anything. So if you're a small company and you might want to do that, get something in writing from the person if they give you their authority. If not, again, keep their name private and move on from there. Now, what you need to do is contact the people who have been in close contact with that person, who have worked with that person. And then you need to issue more than likely go home and work from home if you can, or they need to take time off and quarantine themselves for a while. Again, it will vary on your jurisdiction depending on what's going on, but you need to make sure you take care of those issues. You might need to email coworkers, call coworkers, things of that nature. Next slide, please. Now, the recall plan needs to be in place for the people who've been furloughed, maybe laid off, or in reference to new employees. Obviously, evaluate what you need and follow through with any state and local government legislation that might have been passed. A lot of states and governments are passing some return to work and protection of workers, where if they've been laid off in the pandemic, they need to be the first ones advised of positions that are opening. So look at that and make sure you're following through with that. Obviously, you want to have a non-discriminatory return to work plan in order to bring back your employees. Obviously, the easiest way to bring back employees is to ask for volunteers. If you have enough volunteers, well, then you don't even have to institute any other measures in order to get the people back as you do your staggered return to work program. After that, then you need to decide how best to bring people back. Perhaps it's seniority, depending on what kind of business you're in. Perhaps it's a rotation. And again, going back to the staggered schedules, perhaps you have an A team and a B team, and you put a schedule in place. Obviously, you can also ask people if they continue to work from home, if that works. And if they do say, yes, I'd like to continue to work from home, I advise to set a reevaluation date in a short amount of time so that you can talk to that person again, follow up if remote from home is not going to be a permanent accommodation that you can make. Any of the changes that we're talking about here today will end up going into a handbook. And so, or they should, I should say that. So make sure that you are updating your handbooks, and then any of the new policies with regards to COVID-19, whether it be testing, whether it's the PPE at the job site, whatever it might be, if you're bringing people back, make sure they're acknowledging receipt of the new policies so you have that for the personnel file. And as Tom mentioned earlier, training is very important. You need to make sure you're letting your employees know what the new procedures are and training them. And again, consistency will be key. If your employees are not complying with your policies, it will be very important for you to have a discipline process in place so that way you are treating everyone the same without any type of discriminatory manner. And remember, if you do bring back a laid off employee, it is treated as a new employer or a new employee, a new hire. So make sure you follow all of your normal HR processes. Next slide. There will be certain things and certain issues that some of you may experience that are unique to you. Social distancing in places where machinery is bolted to the ground and you need 3 or 4 people working on a machine might not be possible. All of those things will involve different kinds of conversations and different kinds of policies. So again, the most important thing is communication and putting your policy in place and in writing, so that way you are all adhering to it and people are being trained on it. Some of these instances could involve enhanced instruction, routine or even daily health questionnaires, employee testing we've already mentioned. Next slide, please. A visitor policy is also very important. So you're protecting your employees within your place of employment. But it also is important for tracking purposes down the road if there is exposure or an infection. So you should come up with a plan as to how people are signing in, what kind of contact information you're requesting, and then you can ask them if they've traveled outside of the country, if they've experienced any symptoms, and then you should be prepared into how to respond if someone says yes to one of those questions. Do you ask them to leave? Are you going to allow them in? Are you going to put them into a special room? All of those things need to be specific for your own individual facility. And then, of course, the information is necessary in case you have to follow up in the future in reference to a subsequent positive test result. Next slide, please. A visitor policy that has the form to fill out might not be available for things such as a bank or a grocery store because there's too many people. So make sure you just do a plan that fits for your specifics. Next slide, please. And I'm starting to speed up because I know we're coming upon the hour. We're more than happy to continue for afterwards, but I just wanted to let you know that that is the basis for the speeding up. So the communication plan, we've talked about a lot of these things already today, but the most important thing is to make sure you're communicating with your employees what you expect of them and what they're required to do. Obviously, any type of signage that you put out is very important. Signage is important to your employees, to the visitors, or people visiting your place of employment. And again, disciplinary issues. You are able to discipline people who are not following processes and procedures. So you just need to make sure it's out there, they know about it, so that it is able to be implemented. But again, consistency. You can use various checklists for daily monitoring and, of course, reporting for managers and supervisors. This could be part of the self-monitoring plan that you might put in place with your employees. But again, the most important thing is communication and posting your policies. Oh, goodness gracious. Put a timer on and that's what happens. Next slide, please. Most of these things I've already discussed, so I'm going to move on to the next slide. With regards to workers' compensation, Tom mentioned that I briefly talk about this. I mentioned Illinois and California specifically, since that is where Tom and I are located. Right now, many of you may know that California has enacted a rebuttable presumption that an employee's COVID-19 illness arises out of her employment. It has to be through the time frame of March 19th, 2020 to July 5th, 2020. There's many more details that can be discussed, but we do not have time for that today. Illinois initially had a presumption that was repealed, but then on May 22nd, a new bill has passed and is on the way to the governor's desk. It sounds similar with regards to it being a rebuttable presumption that applies to first responders and frontline workers who are infected, and their end date for that is June 15th, 2020, so shorter time frame than the California one. But what that means is that you need to be on top of these types of cases when they come up, because you're going to need to do your investigations early, you're going to need to maintain detailed records, and you're going to need to coordinate with counsel probably sooner than you would normally. So make sure if any of these things happen, you get this to your counsel and your insurance company as quickly as possible, because time will be of the essence in reference to workers' compensation claims. And with that, I will turn it over to Tom to conclude.
Just a few comments. One, I wanted to make a point on the ADA and accommodation and the interactive process. And Melissa raised a very, very important point about the necessity for employees to actually make a request. And this is unique to this pandemic situation. Typically, an employer just can't ignore something that's right there in front of their face. However, in the pandemic, Melissa's 100% right. The employee should initiate the accommodation process, because as the EEOC has been giving greater latitude on testing and communication measures and taking steps in the workplace, they've also issued guidance which says you cannot make assumptions about an individual's underlying medical condition, which may make them more susceptible to the virus. Consider somebody with with diabetes. You can't make assumptions that that person shouldn't be allowed to work or has to be restricted in some manner, shape, or form. That would violate their rights as well. You cannot make assumptions about those conditions. So I wanted to highlight something Melissa said and make sure you understand it's related really to the pandemic. Now, on the final slide here, consider the unique circumstances related to unemployment benefits. I want to let you know that the FFCRA greatly expanded the state's flexibility to respond to the pandemic. States can extend the terms of benefits if they want. They can cover independent contractors. Not-for-profits who are on a reimbursement basis can have extended time. The DOL, the federal DOL, Department of Labor, has an excellent website which you can access by just Googling in federal United States Department of Labor unemployment relief, and it'll give you great resources state by state. Always consider employee discipline for non-compliance. Treat an employee in this situation like you would treat anybody with a protected factor, as if it was in a discrimination case. Understand the difference between must and recommend in a lot of these regulations and requirements. OSHA in particular uses the word recommend a lot. However, it's almost guaranteed that that would be the standard of care, so to speak, with regard to what you should be doing. And finally, remember that in these circumstances, they're no one's fault. And if you employ empathy in your dealings with your employees, you're going to avoid a lot of potential claims. I know there have been a couple questions. I'm going to hit on one or two here. I know it says if associates are going through a guard shack in the car to be temperature checked, then go to the associate parking lot before entering. Should they be compensated? Under the federal law, there's something called the Portal Act, and everything that is preliminary to the first essential act of employment is not compensated, and everything post-preliminary is compensated. And usually in a lot of cases that have gone to the Supreme Court and the courts of appeals recently, it deals with personal protective equipment, and you should use the same analysis. And so if there's a line outside your premises where it takes 10, 15 minutes to go through that line to the guard shack, then that should be compensated, and you should add that to the time. Once the first act occurs, the first act that's necessary for employment, and every act after that until they end has to be compensated. So yes, going to the parking lot would also have to be compensated. So there is a cost with respect to temperature checks. And I know there was another question here. If an employee is currently working and has COVID-19 symptoms but refuses to be tested, is there a protocol? There certainly is. If they are experiencing COVID-19 symptoms, send them home. Make sure that they will require a test that shows they're clear before they should be able to return. The risk of this highly contagious virus is just too great for someone to have symptoms or even to have been tested positive to come back either too early or while they're still infectious. Melissa recommended or talked about recommended handbook language. You know, the last big pandemic we had in the United States was in the early 1900s, approximately 100 years ago with the Spanish flu. Hopefully we won't have one for another 100 years. Melissa will probably still be alive, but I won't. You know, you have a choice. You can put these pandemic policies into your handbook, or you can have a general reference in your handbook that in the event of a pandemic, the employer has policies that will remain in place. This is one for Melissa. The question is, can you please elaborate on the workers' comp rule in Illinois that sounds like it's in flux regarding COVID-19 diagnoses?
So obviously I don't practice in Illinois, so I don't know as much about the Illinois as I do about California. But if I can have the slide back for the workers' compensation claim. So if I can go backwards one slide. Thank you. So right now, the rebuttable presumption is only noted to apply to first responders and frontline workers who are infected. Now, I haven't dug deep into the Illinois statute to find out what they mean by infected. I can tell you that in California, there was two different things. You could be diagnosed, or you could have a positive test. Now, if you were diagnosed, you would think that you're diagnosed because you have a positive test, but they actually put some details in our presumption in reference to what diagnose means. And I'm guessing that Illinois probably has the same type of thing, meaning what exactly infected is. I'm more than happy to have someone in the Chicago office research that more for you and get back to you. If you want to just send me an email, my email will be on the next slide at the end, and then you can just, and I can let you know and get back to you on that. So I just don't know. All I know is the time frame for diagnoses or infection is through June 15th, 2020. So what that basically means is that my guess is from the time you guys shut down up until the date, June 15th, anybody who is infected as a first responder or a frontline worker will be presumed to have gotten COVID-19 through and arising out of their employment, wherever that might be. And I can give you more details on that afterwards.
And I know the individual who submitted this question, and my guess is that this pertains to the phrase rebuttable presumption. What does that mean? Obviously, there's a question of were they infected in the workplace, or were they infected at home, or were they infected on public transportation? And the answer is that there will be a rebuttable presumption for those work categories. That means that it will be assumed that it happened at work, unless you can show as the employer with some good evidence that it didn't happen at work. So, for example, if an employee comes down with COVID-19, and 3 or 4 days earlier, the employee had noted that every single person in their household had tested positive, you now have evidence that can rebut or dispute the presumption that applies, and it might not be a work-related illness.
Right, and like I said on the in the presentation, investigating early is going to be one of your best lines of defense, because the sooner you get some information in order to see if you can rebut the presumption, the better off you may be. California has actually added that we only have 30 days in which to actually rebut. So you've got 30 days in which to issue a denial that says this is not related to their employment. And in so doing, they've gone so far as to say, down the road, you are unable to use evidence that you could have obtained in those first 30 days. So again, not practicing in Illinois, I don't know if the Illinois bill has any of that, and we'll have to see what, when it gets final. But that's one of the big issues. So one of the other things I'd recommend, if in this case with the rebuttable presumption, do your social media checks and your investigation quickly, because what if, as Tom said, they've been out with groups of people, they've attended something, were at a party, and there's pictures on social media. You just never know. But the main thing is investigate early, and of course documenting everything of what these people are doing if you find out that they are doing something other than work and what they are doing.
All right, we'll take one more question, and the question is, if an employee is sent home due to symptoms, must they be paid, or are they only paid once they have tested positive? Well, first of all, if an employee has symptoms, you have every right to send them home, but it varies depending on whether or not the employee is salaried, exempt, or whether they're hourly. If the employee is hourly, they're only paid for the time they work. But you may have policies that if an employee shows up, they're paid for at least a certain number of hours. A lot of union contracts have a 4-hour provision. If a salaried exempt employee works at all during a work week, they must be paid for the entire week. So that's a potential reminder. There may be some exceptions to that, but they will be few and far between. So if we can go to the final slide, we finished the questions and answers, and I would like to thank all of you for attending the webinar. Here we are at Hinshaw, and we're very happy to help you and your businesses. We hope you found this valuable. The slides would be available to all of the participants as useful checklists for you, and we hope you found it a value. So please stay safe, and we look forward to connecting with you in the future. Goodbye.
And for any of you that are California employers who may have questions that were not answered today, please feel free to email me, and I'll be more than happy to assist you with whatever questions you might have as they relate to California. Thank you again.